Hello, everyone. My name is Attorney Shawn Smith, and I am an elder law attorney here at RTR Law. I am so excited to present to you this seminar on elder law. It's going to educate you in the documents that you need to protect your future and to secure a legacy for your loved ones that will last forever. Stay tuned. I'm thrilled that you have taken the opportunity to view this presentation. Today, what we're going to be talking about is estate planning. At RTR Law, we get so many questions about what is the right estate plan for you. And here, what we like to do is be able to answer those questions, but also educate individuals so they know what works for them. Basically, by watching this video, you're going to know the basics regarding estate planning and some of the things that happen during the estate planning process. The first question you may have is exactly what is an estate plan? As the word says, it's a plan for your estate or for your assets, not only when you pass away, but also importantly, while you are still alive. We're going to be going through some of the documents, in essence, 5 essentials to the estate plan that will work for you. The first document that we want to talk about is a very powerful document. Many of you have probably even heard of this document called the Power of Attorney. You may ask, what is a power of attorney? The basic definition as we read it here says, a power of attorney is a legal document delegating authority from one person to another. In the document, the maker of the power of attorney, which we call the principal, grants the right to act on the maker's behalf as that person's agent. What authority is granted depends upon the specific language of the power of attorney. A person giving a power of attorney may make it very broad or may limit it to certain specific acts. So let me explain that just a little bit more. The person or individual that creates the power of attorney or signs the power of attorney, that person is called the principal. They're going to be designating somebody else. Oftentimes it's a family member. It may be a spouse. It may be a child. It may be a trusted individual. That person is called an agent. The agent is authorized to do specific acts on behalf of the principal. Those acts are going to be outlined in the power of attorney itself. Now, as we look at power of attorney, there is a specific power of attorney called a durable power of attorney. And it's called durable is because even after the principal becomes incapacitated, the agent can still do things on their behalf. A power of attorney is very important when a principal needs somebody to make financial decisions for them. Those decisions include having access to a bank account. Those decisions include dealing with real estate or dealing with property. Those decisions include dealing with Medicare and Medicaid. A durable power of attorney is a very important, I'll even say a powerful asset in the tool of any estate plan. And here at RTR Law, we educate you, advise you, and we even create these documents on your behalf. Another important document in an estate plan is documents called advance directives. What advance directives are is essentially you're telling the medical provider what sorts of decisions you want to make in advance. Essentially, anytime you go to a hospital, they're going to ask you if you have an advance directive. Now, when you get this question, we're going to educate you so you know what is it they mean when the hospital officials ask you this question. An advance directive is a statement about how you want medical decisions made should you not be able to make them yourself. Some people make advance directives when they are diagnosed with a life-threatening illness. Others put their wishes into writing while they are healthy, often as a part of their estate planning. Here at RTR Law, we want to advise you to make these decisions in advance while you are still healthy. Don't wait till you're sick. Don't wait till you are on your deathbed, but make these decisions in advance. Now, what are the legal documents associated with advance directives? The 2 major documents that we talk about are the living will and the healthcare surrogate. I'm going to repeat that for you. The living will and the healthcare surrogate. Let's first start talking about the living will. The living will oftentimes gets confused with the last will and testament. And I hope that by listening to this presentation, you understand the difference and know what each one does in your estate plan. What is a living will? A living will is a written statement outlining the kind of medical care you want or do not want if you become unable to make your own decisions. It is called a living will because it takes effect while you are still living. Let me repeat that for you. A living will takes effect while you are still alive. While you're alive, while you're in the hospital, while you need medical care, while you need medical treatment, the living will would dictate to medical professionals what your decisions are. It says that if you are in an end-stage condition, a terminal condition, or a persistent vegetative state, you would not want certain life-prolonging procedures. So basically, a living will says under what circumstances you want to be kept alive and under what circumstances you just want the medical professionals to let you go ahead and pass away. It talks about in what situations you want them to withhold life-prolonging measures. What are some examples of life-prolonging procedures, you may ask? Now, some basic life-prolonging procedures can include withholding life support, such as a feeding tube, ventilation, surgery, dialysis, pacemakers, and more. The example that I often talk about in reference to the living will is a story, a very popular story that took place way back when I was in law school, and that was the life of an individual by the name of Terry Schiavo. In that situation, we had a disagreement between Terry Schiavo's parents and Terry Schiavo's husband. They wanted to determine under what circumstances did Terry Schiavo want to remain alive and under what circumstances Terry Schiavo wanted to go ahead and pass away. That decision would have been easier if there was a living will that could have been looked at, because a living will would have told everyone in advance what her decision would have been. The difference between a living will and a DNRO, a lot of individuals have heard of DNRO, and DNRO essentially means do not resuscitate order, and that's a medical term that you will hear. And sometimes people get confused between a living will and a DNRO. A DNRO deals specifically with the refusal of cardiopulmonary resuscitation. All my nurses and doctors and CNAs understand that terminology. A DNRO deals specifically with CPR in the event of cardiac or pulmonary arrest. It is a physician's order signed and dated. So that is the difference between a DNRO and a living will. A DNRO deals with a specific type of life-prolonging procedure, and that procedure is called CPR. Now, another advanced directive is called the health care surrogate. It is a document naming another person as your representative to make medical decisions for you if you are unable to make them by yourself. You can include instructions about any treatment you want or do not want, similar to a living will. You can also designate an alternate surrogate. Essentially, what a healthcare surrogate is, you are designating somebody else to make medical decisions for you, to make healthcare decisions for you. Simply put, it comes into practice if you're in the hospital and you cannot make those decisions on your own, and the hospital professionals need somebody of which they can talk to determine what type of procedures they can or cannot perform on you. So this is a person who's going to be making medical decisions on your behalf. Now, I don't want you to get confused between a durable power of attorney and a healthcare surrogate. And one easy way to determine the difference is that you're going to use a healthcare surrogate when dealing with health issues or health concerns, or most importantly, when you're in a hospital. A durable power of attorney is when you're dealing with financial or property issues, and you'll use it a lot when dealing with banks and other officials of that particular nature. But both are important in any estate plan. Both designate somebody on your behalf to make these decisions for you when you cannot or if you are unable to do so. Another thing that we want to talk about, if you don't have these things in place, right, is something called guardianship. Now, previously, we've talked about the durable power of attorney. we've talked about advanced care directives, of which there are two major advanced care directives, the living will and the healthcare surrogate. The other thing we want to talk about is guardianship. What is guardianship? Guardianship essentially is when you have to go to court. Well, why would you have to go to court through a guardianship process? A guardian is an individual or institution such as a nonprofit corporation or bank or trust department appointed by the court to act on behalf of an incapacitated person called a ward or for the ward's assets. Remember when I talked to you about the durable power of attorney? How it's durable because even if the principal is incapacitated, the agent will be able to act on their behalf. Now, if you do not have a durable power of attorney, then the process that you have to go through to act on behalf of an incapacitated person is called the guardianship process. You have an individual who cannot make decisions for themselves. They do not know what's going on, and you want to be able to help or assist them, but you don't have a durable power of attorney. What you're going to have to do is go through the process called guardianship, as that's when you petition the court. You petition the court on two avenues. One, you're saying, listen, court, I want to be the guardian for the ward. I want to be the guardian for the incapacitated person. Typically, we're dealing with older or elder adults who can't make decisions, or it can even be younger individuals. And you're saying, listen, court, I want to be the ward. In addition, you're petitioning the court to say, listen, this individual is incapacitated. They cannot make decisions on their own. When you petition the court for this process, the court then is going to assign 3 professionals to do an evaluation on the ward to determine if they are indeed incapacitated and they indeed need a guardian. They're going to file that report with the court. Then ultimately, the court's going to make a decision of 1, is a person incapacitated? And 2, does this individual need a guardian? And they're going to appoint a guardian for the person, and they're going to appoint a guardian for the property. They will appoint a guardian for the person to dealing with their personal effects and health issues, and also for the property, dealing with their assets and dealing with whatever money they have coming in and out. Now, the court is going to be very strict with you. The court is going to determine what the guardian can and cannot do. The guardian is going to have to get authorization to act on behalf of the ward. They're going to have to ask the court for authorization to pay certain things, to fix certain things on the house. And they cannot do those things on behalf of the ward unless they get the court's permission. Like anything dealing with the court process, the guardianship process takes a long time, and of course, it's going to cost additional monies. That's why it's very important to have a durable power of attorney in place. That's why it's very important to have a healthcare surrogate in place so that you can avoid the guardianship process. But if you don't have those things in place, be sure we will be going through guardianship so that you can act on behalf of the ward. The other thing that we want to talk about in any estate plan documentation is probate. Oh, many people know, or they may not know about probate. I wonder, if you're watching, if you've had an experience with probate, or you know someone that's had an experience with probate. Well, what is probate, you may ask? Probate is the court-supervised administration of a decedent's estate. It is a process created by state law to transfer assets from the decedent's name to his or her beneficiaries. Let me slow that down and say that for you one more time, because this is the crucial part about the probate process. It is a process created by law to transfer assets from the decedent's name into the name of his or her beneficiaries. Oftentimes we see this when individuals have bank accounts or they have a house that's in the decedent's name, and the beneficiaries now contact our office and they need to change the name from the decedent into the name of the beneficiaries. And the process of which we go through to get that done is a court supervised process called probate. A personal representative is appointed to handle the estate administration in some cases. The probate process ensures that creditors, taxes, and expenses are paid before distribution of the estate to the beneficiaries. And there are 2 major probate processes here in Florida, and that's formal probate and summary probate. formal probate and summary probate. Depending upon the amount of assets involved in the estate, will determine which process you will go through. The summary probate process, of course, is much quicker than the formal process. But regardless, this is a court-supervised process where we have to petition the court and we have to request certain things and wait for judges to sign orders before the assets can be changed from the name of the decedent to that of the beneficiaries. And of course, in any court-supervised process or any court process, it's going to take time and it's going to cost extra money. So that is why we oftentimes educate individuals on how to avoid probate with their estate plan. So a quick review on some of the things that we've talked about already. The first thing we talked about is a powerful tool called the durable power of attorney. The next we talked about advanced directives, which include a living will and a healthcare surrogate. Then we talked about the first court-supervised process for someone that's living, which is called the guardianship process. That's when we petition the court on behalf of the ward who is deemed incapacitated, and the guardian can then act on behalf of the ward. The next thing we've talked about is probate, the probate process where we are transferring assets from the name of the decedent into the name of his or her beneficiaries. Now, another tool, another thing that we want to talk about is one of the famous documents you hear about in any estate plan, the last will and testament. I'm sure if you are listening to this seminar, you have heard about the last will and testament. You are familiar with the last will and testament. You have maybe even contacted attorneys asking for the last will and testament. And we at RTR Law get many questions on this. So there are many misconceptions about the last will and testament. First, let me give you a basic description of what it is. A will is a written direction controlling the disposition of property at death. Basically, it says, when I die, this is what I want to happen with my assets, and this is where I want my assets to go. That is the general description. My description of what I tell anyone that gives my office a call or contacts me and asks me about a will, I tell them this. Repeat after me. A will is not a way to avoid probate. Say that again, I couldn't hear you. A will is not a way to avoid probate. Remember when we talked about probate just a few minutes ago? If you want to avoid probate, the last will and testament is not the way to do it. A will essentially is a ticket to the courthouse. And when the court reviews the probate case, they're going to be looking to the will to determine where the assets are going. Who's to get the car? Who's going to get the house? Who's going to get the money? They're going to know based upon what's written in the will. And when I use the word they, the court will know based upon what is written in a will. Now, if you want to avoid probate, if you want to make sure that you don't have to go through this court-supervised process, you're going to look at another document. That document is called the Revocable Living Trust. And you're probably listening to this seminar because you have questions regarding the Revocable Living Trust and how that may help in your situation or circumstance. So let me briefly tell you the definition of the Revocable Living Trust. A revocable trust is a document or a trust agreement created by you to manage your assets during your lifetime and distribute the remaining assets after your death. The person who creates a trust is called the grantor or the settlor. The person responsible for the management of the trust assets is the trustee. You can serve as trustee, or you may appoint another person, bank, or trust company to serve as your trustee. The trust is revocable since you may modify or terminate the trust during your lifetime as long as you are not incapacitated. Simply put, the trust document, the Revocable Living Trust, is a major way to avoid probate. Now, there's several different types of trust, and we're not going to get into that in this particular seminar, but for a basic estate plan, if you want your assets to avoid probate, you're going to put it in a trust, right? And since you are the individual putting these assets in the trust, you will consider yourself the trustor. Now, you don't want to lose ownership. You don't want to lose authority over these assets. So you will also be designated as the trustee. So you will still control these assets, whether it be the house, whether it be that particular bank account, whatever the asset may be, you will still have authority and legal control over these assets as the trustee. But the crucial tool in any revocable living trust is that when you pass away, you can forget about probate. You can forget about going to court. You can forget about that entire process, and you can transfer your assets to the beneficiaries and avoid the probate process. Now, you will find this definitely important if you have minors. If you have a minor and you want to make sure you pass your assets to your minor, the only way or the best way to do it is through a revocable living trust. Don't give your money to your kids. Don't give your money to your children. Put it in a revocable living trust on their behalf. And as they grow, as they mature, as they get wise in age, you can distribute the money to them at that particular time. And also while they're growing, you can use that money for their health, for their education, and for their maintenance. So the major way to avoid probate is through the revocable living trust. Now, there's one other special item that I want to talk to you about. Another way that you can avoid probate, and that is called a ladybird deed or a life enhancement deed. What is a ladybird deed? A ladybird deed is a legal form that transfers property upon death inexpensively and without probate. A ladybird deed allows the current property owner to use and control the property during the owner's lifetime, while the property automatically transfers upon death to the designated beneficiaries. A ladybird deed is great if you're trying to transfer real property to a beneficiary and avoid probate. Basically, if you have a ladybird deed, it says that while I'm alive, while I'm still living in the house, or while I'm still renting out the property, I'm in control. But when I die, all my beneficiaries have to do is file the death certificate with the property appraiser's office, and that asset transfers automatically to the beneficiaries and avoids the probate process. The ladybird deed may be an essential and important tool in your estate plan, but the only way to find out is for you to give us a call, and we will talk to you about your specific situation. I want to briefly review the documents and items that we talked about today. First, we talked about the durable power of attorney and how that assists and helps you taking care of elder individuals or somebody that may be deemed incapacitated. Then we talked about advanced care directives. What are two important advanced care directives? That's the living will, which dictates what kind of life-prolonging procedures you want to be withheld while you're still alive. And then there is the healthcare surrogate, which dictates who is going to be making medical decisions on my behalf. After that, we talked about the guardianship process, how if you are incapacitated and you do not have the right documents in place, you then have to petition the court to act on behalf of the ward, and you have to get authorization to do certain things on their behalf. In addition to the court-supervised process concerning guardianship while you're alive, we talked about the probate process that talks about the court-supervised process of transferring assets after you have passed away. We talked about the cost and time it's going to take. We indicated that there are two types of major probate processes here in Florida, and that's summary probate and formal probate. Then we talked about two more important essential estate planning documents, which is the last will and testament, not to be confused with the living will, but the last will and testament outlines where you want your assets to go after you have died. Then we've talked about the revocable living trust. And this is a document, an agreement that you create to transfer your assets after you die, but you also have authority over these documents, not documents, but assets while you are still alive. But the most important thing about the revocable living trust is that you avoid probate if those assets are in the trust. And then we talked about, finally, the special ladybird deed. And this ladybird deed transfers property after you die automatically to your beneficiaries and also avoids probate. However, it can only be used for real property. It's been a pleasure presenting this important information to you. I hope that it was able to assist and help you understand what's important in your estate plan. Now, I'm going to invite you to give us a call. You're going to see the number here on the screen. We have offices throughout Florida, in Tampa, in Fort Lauderdale, in Lake Worth, in Orlando, where we can help and assist you throughout the state. So give us a call today. Find out what estate plan would be important for your specific situation. We love educating individuals about these important documents because we want you to put these documents in place for you. We love helping you protect your loved ones and help them secure their future so that they can leave a legacy that will last forever. Thank you.